Hello and welcome to Business Talk, brought to you by the Sharonville Chamber of Commerce. I'm Britt Scarce with Emory Federal Credit Union. I'm your host, and today here in studio we have Karl Ulrich with Sebaly, Shillito Dyer here to talk to us about the EEOC. Karl?
Hey, Britt.
How you doing? Welcome.
I'm doing well. How are you?
Great. So what the heck is the EEOC?
The EEOC stands for Equal Employment Opportunity Commission. It's an arm of the U.S. federal government.
Okay.
And in a nutshell, what the EEOC does is investigate and help enforce employment laws.
Okay.
So an employee may have a claim against an employer for workplace discrimination, and they may file a charge of discrimination with the EEOC. And so the EEOC is responsible for investigating those claims, asking for information from the employer, asking for information from the employee. The process is part of an investigation, and at the end of the investigation they come out with a recommendation or decision which might ultimately involve a settlement, or it might eventually end up in court. But the EEOC is designed as a kind of pre-court, pre-litigation investigation arm to resolve some of these things prior to formal litigation in a court of law.
Okay. So tell me what kind of discrimination, that takes a lot of forms.
Right.
So what would rise to the level of, having to be investigated by the EEOC?
Well, the EEOC, as a federal government commission, is charged with investigating violations of federal law in the employment context. Not all federal laws in the employment context, but mainly Title VII. So we're talking about discrimination on the basis of race or religion or gender. It also investigates age discrimination type claims. It investigates retaliation. So if you have a claim by an employee who may have believed that they're discriminated against on the basis of their sex, for example, and the employer hears about the claim or hears about the complaint and then reassigns them or punishes them somehow for making the complaint in the first place, that's a retaliation claim. So that's part of the EEOC's portfolio of responsibilities. And those are the kinds of claims that they investigate. Now, they don't, EEOC is not responsible for wage and hour type investigations. That's a different federal government agency. That's actually the Department of Labor. Or family and medical leave. That's a different Department of Labor.
Wow, it's amazing that we need so many departments. There are so many, people behaving badly that.
Well, and the EEOC is just the federal government version. There's a state government. A lot of states have their own agencies that do essentially the same thing under state law. So in Ohio, for example, there's the Ohio Civil Rights Commission, the OCRC, we call it. And the OCRC does has a similar process that the EEOC has, but they're also investigating state law claims. Sometimes the EEOC, you can file a charge in both agencies at the same time. So those are called dually filed charges, and those charges are investigated. The EEOC will sometimes defer to the state agency, allow the state agency to investigate those, and then once the state agency, the OCRC, comes up with a determination of some kind, then the EEOC will review that and either sign off or there may be a further activity by the federal government version. So the two state and federal sometimes work hand in hand on charges, but there are a number of different organizations within the federal and state governments that investigate different types of claims, different types of complaints and disputes within the employment context.
Okay, so as an employer, how should you prepare yourself if you're all of a sudden finding yourself having to interact with the EEOC or the state version of that?
Right. Well, oftentimes the EEOC process isn't even the first step in getting notice of a dispute. So you may have an employee who claims some kind of discrimination that you might receive first notice of that through counsel, through legal counsel. You might have a complaint lodged informally by the employee within the HR function. So there may be a whole number of ways that you get first notice of those issues even before the commissions get involved. But to answer your question more directly, I think as soon as you're aware of a claim, as soon as you're aware of a potential dispute, obviously the first thing you've got to do is make sure all the materials, all the information that's relevant to the dispute, personnel files, write-ups, whatever the documentation is that the HR function or the company may maintain on that particular issue is preserved, because not only is it important for the employer's defense, but it's going to be an issue if some of the information that's relevant to the case has been lost or destroyed. Obviously, that doesn't look real good.
Yeah.
Even if the information would have been helpful to the employer, the fact that it's no longer there is not a good thing for the employer, and so that can be a problem. But preserving information is a critical first step, and then
they're going to need legal counsel too.
Well, and they're going to need legal counsel. Yeah, I mean, I think
don't try to handle this on your own, I would assume.
As a lawyer, you'd expect me to say that,
yeah,
right?
Yeah.
But I think for the most part, yeah, you want to be advised well, and so I think having assistance from legal counsel is useful and very important. In some cases, almost indispensable. You really shouldn't be doing these things on your own. But then what happens, of course, is that you get a copy from the agency, the commission, excuse me. It's called a charge of discrimination, and a lot of this is now done online because federal government has been going more toward online portals for this sort of information. So you can get this, you can get the files, you can get all the charge information online, and then sitting down with legal counsel and reviewing those charge specifics. It's a form that an employee would fill out when they go to the EEOC. They'll fill out this form. They'll explain the reasons why they believe they've been discriminated against, and that form becomes the starting point. And so you really need to, if you're employing legal counsel, and you want to sit down with legal counsel very early on and look through that charge. What are the particulars? What are the specifics of the allegations made in that charge? Are they true? Are they partially true? Are they completely false? You get a good sense early on by reviewing the files with counsel about kind of process you're going to be looking at. The other question you're going to be facing early on in a commission proceeding is you're going to be given the opportunity to mediate. Mm-hmm. As opposed to fighting the good fight, sometimes it makes sense to sit down with the other side and try to resolve it. Mm-hmm. And the great thing about the EEOC and the House Civil Rights Commission processes is that they have some fairly good processes for mediation and settlement. Mm-hmm. You can actually sit down with a mediator, and that mediator will talk to both parties, and will try to facilitate a settlement discussion, settlement negotiation. Mm-hmm. And oftentimes those can be much less expensive, those settlements, than proceeding through the full process either before the EEOC, and certainly once you get to court, it's going to be a lot less expensive if you can settle early. Mm-hmm. So you utilize those resources with the commissions, and they're free. I mean, other than the cost of counsel, other than the cost of your time and effort, the commissions do their work using taxpayer funds, so you don't pay for that. And
do they do anything to help root out, the more frivolous claims and maybe the false claims, that sort of thing? I mean, mm-hmm. I know there's plenty of legitimate ones, I'm sure, but I'm sure there are some that are, someone's just has an axe to grind, and they kind of make a story up, and, do they try to root some of that out? I mean, or do employers end up, a lot of times having to pay even though they did nothing wrong?
Well, it's a great question. I mean, I think the investigators, both federal investigators and the state commission investigators, are pretty well trained, very, very sophisticated folks. They understand the laws. There are a lot of claims, for example, that, not a lot, but there are many claims that come in, and it's just obvious from the particulars that they've waited too long to bring the claim. Whether it's has merit or not, it's just out of time, so that one won't get investigated. There may be some very obvious things about the charge particulars themselves that investigator will look at and said, well, we're not going to pursue this. We're not going to investigate it because of one thing or another. So they do early on look for, I think, certain signals, certain aspects of the charge that might disqualify them right off the bat. But for the most part, I think the investigators want to get to the truth, and so what they're doing is even if they may have their own suspicions about one side or the other, they're going to allow the process to proceed because they want everybody to get a chance to present their case. And I've been doing this for a long time, and my experience with the investigators has been they're really pretty even-handed. They're pretty fair, I think, for the most part, and want to do the right thing. So I think if you've got a good case, if you've got a good argument to make, you'll be heard. On either side of the table.
Okay, so it's one of those things where you don't necessarily want to have to go through anything like this, but if you do, there's a good chance you're going to be treated fairly, as like you're saying. It's not like it's going to be everybody who brings a claim is well, this is just a way for me to easily get. I'll just shake them down for a couple $100,000 just by saying, hey, this guy let me go because I was 53 years old. But
yeah, I mean, one thing to note too is that the Commission isn't there to render a final decision in these cases. The Commission usually will investigate it, and the result of that investigation, unless the matter is settled or mediated to a conclusion, unless it's settled, the investigation will result in what's called a probable cause or no probable cause determination. So in other words, the investigator says, based on the evidence that I've reviewed, either I think that there's probable cause to believe that a violation of the law has occurred, right? Or there's just no probable cause, there's not enough evidence to substantiate a charge, and then dismiss the complaint. So, it is kind of a preliminary view, a preliminary review of the case. Now that may ultimately then end up in court. The vast majority of charges that get investigated usually end up being dismissed for no probable cause. But there are a few smaller percentage where there are probable cause determinations that may ultimately have to be resolved later on or end up in court to be fully litigated before a judge or a jury.
So if we find ourselves in this situation as an employer, preserve the information, make sure that all the pertinent information is pulled together and protected. Utilize the free resources that the EEOC has, probably also obtained counsel to kind of help guide through this. This is probably a lot of stuff that an employer probably hasn't gone through before, so it's probably a good idea to have, I'll say it for you, since you're, like you said, as an attorney, we kind of expect you to say that, but I think that would be a prudent thing.
Right.
But, and it doesn't necessarily always mean that it's going to end up, if it's frivolous or something like that, it's not going to necessarily always going to end up that the employer is going to have to necessarily lose or that kind of thing.
Yeah, those frivolous complaints, when they become apparent that they're frivolous, they get rooted out. And that's really part of the process. That's part of the reason these commissions exist, is so that we don't have to go to court with those kinds of cases. They can be resolved early.
Man, that's great information. Very, very good. Our guest has been Karl Ulrich with Sebaly, Shillito Dyer, telling us all about the process of the EEOC. If you happen to find yourself in the situation where you're having to deal with them, I think there was some valuable insights here provided by Karl here today. So you've been watching Business Talk. Until next time.